CR 0051 and 25 CR 0066. Are you Bobby Garman?
Yes, sir.
Good morning. Were you born in 2001?
Yes, sir.
Last four digits of your social security number 1566.
Yes, sir.
What does the Commonwealth have to say?
Yeah, felony plea, Your Honor.
Your Honor, just, he hadn't signed the updated paperwork yet. If I can just have a moment with him.
Yeah, this is one our staff did last night, so
Okay,
I laid out the wrong files, my fault.
okay. What are you gonna do about the rest of your cases here?
If,
I'll tell you what, let's just stop here for about 15 minutes. Whatever, you get done what you need to do and the people in drug court come back up here and we'll start again. Go ahead. Let's go off the record. Yeah.
Is it more official than everything?
Are you still Bobby Garman?
Yes.
Okay. We're at 25 CR 0051 and 25 CR 0066. I understand that there's a plea, is that correct?
Yes, sir.
Motion's been tendered that says you wish to enter a plea. Are you currently under the influence of drugs or alcohol? Is this plea freely and voluntarily given? Are you the same person we just identified in 25 CR 0051 and 66? Is your judgment impaired today in any way? Is your judgment impaired? Do you know what's going on here? Yeah. Have you discussed this matter with your attorney? Are you satisfied with his advice?
Yes, sir.
Have you viewed the evidence the Commonwealth has against you? Believe you're fully informed about your case? You understand that you do not have to enter a guilty plea. You have certain rights under the Kentucky and United States Constitution. Before I can accept a plea, I need to know that you understand those rights. You have the right not to testify against yourself. No one can make you say anything. Right to speak trial by jury, right to be represented by counsel in your jury trial, right to confront and cross-examine all witnesses called to testify against you. Right to produce evidence, right to call witnesses in your own behalf and have process issued to compel their attendance. You have a right to appeal this matter to higher court if you lose, and a right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty of charge. You understand by the entering guilty plea today, you give up those charges. Those rights. You know that? Now, I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided by law. I don't have to accept it. Prior to accepting the recommendation, I will wait a pre-sentence investigation report done by probation and parole. In the event after reviewing that, if I decide not to accept the recommendation and decide to impose a harsher sentence on you, you have a right to withdraw your plea and proceed to trial. Do you understand that? Who is presenting the Commonwealth's recommendation?
Your Honor, Mr. Garman will plead guilty in 25 CR 66, charge of theft by unlawful taking over $10,000, receive a sentence of 10 years. In indictment number 25 CR 51, he'll plead guilty to theft by deception, receive a sentence of 5 years. Those two sentences shall run concurrently for a total of 10 years, probated for 5 years supervised. He'll pay restitution in 25 CR 66 in the amount of $16,000 at the rate of $150 a month. In 25 CR 51, he'll pay restitution of $4,205 at the rate of $150 a month, making his total restitution $300 a month. Those debt payments will be due prior to final sentencing due on the same day each month thereafter, subject to a clerk's fee of 5%. He'll have no contact with the victims. The defendant's supervision and probation shall remain active until all restitution is paid in full. He'll enter and complete the Cumberland County Specialty Court and receive credit for time served. And we're asking that this case be placed back on the docket in December of 2026 so that his restitution can be reviewed and see if he can pay an additional sum because his total is over $20,000. He's only paying $300 a month till he gets started. And he pay court costs at discretion of the court.
What was it probated?
It's probated.
How much time?
10 years probated for 5 or until the restitution is paid in full.
So it became a C felony, dude?
It did. And the reason it's probated, he's got cases in 2 other counties, so I don't think a diversion would be feasible in this case.
Great. Now, is that what you agreed to? Is that your understanding of your recommendation?
Yes, sir. Yes, sir.
Are you pleading guilty because you did commit the acts charged in the indictment as amended?
Yes.
Are you doing so your own free will?
Yes, sir.
You know, your constitutional rights explained to us, it's still your desire to enter a plea and allow the court to fix your punishment within the limits of law.
Yes, sir.
And you understand that after entering a guilty plea today, any future convictions that you might be could be enhanced under the persistent felony offender law.
Sir.
Is that your signature on the document there?
Yes, sir.
Okay, I'll accept the agreement, order pre-sentence investigation report. It is scheduled sentencing for January the 22nd. Remain free on the same bond. Terry Aaron, you have an affidavit now. Fill affidavit out. Mr. Aaron, I'm going to go ahead and appoint you a public defender. And I'm going to reserve to later determine how much, if anything, I charge you for it. You are Terry Aaron.
Yes, sir.
Hey, Mr. Aaron, you have a right to remain silent. You're represented by counsel now. The grand jury of Cumberland County has returned an indictment charging you with possession of controlled substance in the first degree methamphetamine. Do you understand what that charge is?
Yes.
Okay. Mr. Bailiff, you present that to counsel. Counsel, you acknowledge the identity of your client, receive the indictment, waive formal reading and arraignment, enter plea of not guilty, reserving all pretrial motions.
Yes, Your Honor.
Okay, what is your negotiation day this week?
January the 16th, 9 a.m.
Okay, you should be here at January 16th at 9 a.m. for negotiation. And your next court appearance is January 22nd. Both of those are conditions of your bond. Do you understand that?
Yeah.
So you need to make arrangements to meet with your attorney to prepare for that negotiation day. No objections. You can remain free on the bond that you make. Okay,
Thank you, Your Honor.
okay. Matthew Day, Commonwealth versus Matthew Day. I'm signing reciprocal discovery on that last case.
Yes, Your Honor. Thank you.
Are you Matthew Day?
Sure.
Good morning. This is 25 CR 0069. Mr. Day, were you born in 1987? Last four digits, social security number 6558.
Yes.
We're here on the pretrial conference. What does the Commonwealth have to say?
We have a probated felony plea, Your Honor.
Okay, a motion's been tendered that says you wish to enter plea today. Is that correct?
Yes.
Okay, you need to answer up.
Yeah.
It's,
Yes,
the
yes, sir.
reason is it's a voice activated and the camera doesn't go on until then. Okay, you see what I'm saying? Are you currently under the influence of drugs or alcohol? Is this plea freely and voluntarily given?
Yes.
Are you the same person named in indictment number 25 CR 0069? Is your judgment impaired today in any way? Have you discussed this matter with your attorney? Are you satisfied with his advice?
Yes.
Have you viewed the evidence the Commonwealth has against you? You feel like you're fully informed about your case?
Yeah.
You have certain rights under the Kentucky and United States Constitution. Before I can accept a guilty plea, I need to know that you understand those rights. I'm gonna go down through them at the end and ask you, okay? You have a right not to testify against yourself. No one can make you say anything. Right to speak trial, but jury right to be represented by counsel at your jury trial. The right to confront and cross-examine all witnesses called testify against you, right to use evidence, right to call witnesses in your favor. The right to appeal this matter to higher court if you lose, and the right to require the Commonwealth to prove you on a reasonable doubt that you guilty charged against you. Understand that by entering a guilty plea today, you give up all those rights. You understand that? I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided below. I don't have to accept the recommendation. Prior to accepting any recommendation, I will wait the precinct's investigation report on probation and parole. And then I do not accept the recommendation after reviewing that report and decide to impose a harsher sentence. You have a right to withdraw your plea, go to trial. You understand that?
Sir.
Mr. Hunley, are you going to present the
I
comments?
am, Your Honor.
Please proceed.
Upon a plea of guilty to possession of a controlled substance first degree, the defendant shall receive a sentence of 3 years, probated for 5 years with the probation to be supervised. Upon plea of guilty of operating a motor vehicle with alcohol concentration above 0.08 or while under the influence of alcohol or other substances, first offense, the defendant shall pay a fine of $200. The defendant shall enter and complete the Cumberland Specialty Program. Defendant shall obtain gainful employment or do a minimum of 30 hours community service each week until gainful employment is obtained. The defendant shall pay all fines and court costs at the discretion of the court, and he agrees that any evidence in this case be disposed of in a manner consistent with the laws of the Commonwealth.
You also, in addition to this felony being enhanceable, you realize that the DUI is enhanceable too. So if you get another DUI, that it'd be more severe penalties and it's sanctioned and bracketed up. You understand that?
Sir.
Okay. Are you pleading guilty to that, to the acts that are stated in the amended indictment because you did commit those acts?
Yes.
Doing so your own free will. Knowing your constitutional rights explained to us, it's still your desire to give up those rights, enter plea guilty and allow the court to fix your punishment within the range permitted by law.
Sir.
You understand, and I told you this is the felony and the DUI are enhanceable. Is that your signature on the document and the offer?
Yes, sir.
You have the DUI document
I do.
completed. I'll accept the agreement, order pre-sentence investigation report to be done for probation and parole. You come back here on January 22nd for sentencing. I'm going to allow you to be released on the same bond that charge. You come back here, probation parole officer is there. Absolutely don't be operating a vehicle. Okay? That's it. Thank you. Caroline Hardison.
That was Mr. Wallace, just to sign it.
Okay. Robert Kelly. Robert Kelly. Commonwealth versus Robert Kelly, 25 CR 0070. Are you Robert Kelly?
Yes, sir.
Good morning. Are you born in 1977?
Yes.
Last four digits, social security number 4514.
Yep.
You're on 25 CR 0070 for a pretrial conference. What do we have?
It's a felony plea, Your Honor.
Okay. A motion, I've just been informed that a motion has been tendered that you wish to enter a plea today. Is that correct?
Yes.
Are you currently on some kind of drugs or alcohol? It's plea, freely and voluntarily given. Okay. Now, you're the same person that we, just identified in 25 CR 0070. Is that correct?
Yes.
Have you, is your judgment impaired today anyway? You know what's going on? You have to say something because it's voice activated microphone. Are you impaired today?
No.
Okay. Have you discussed this matter with your attorney and are you satisfied with his advice?
Yes.
Okay. Now, have you reviewed the evidence Commonwealth has against you? You believe you're fully informed about your case?
Yes.
You understand that you do not have to enter a guilty plea today. You have certain rights under the Kentucky United States Constitution. Before I accept the plea, I need to know that you understand those rights. I'm gonna go through the rights. And at the end, I'll ask you if you understand. If you have any questions, you can step away and talk to your attorney. You have a right not to testify against yourself. No one can make you say anything. Your right to speak trial, but jury right to be represented by counsel as your jury trial, the right to confront and cross-examine all witnesses called to testify against you. Right to be evidence, the right to call witnesses in your favor, the right to appeal this matter, higher court if you lose, the right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty of the charge against you. You understand that by entering this guilty plea, you give up those rights. You understand that?
Yes.
Okay, I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided below. I don't have to accept the recommendation. Prior to accepting any recommendation, I will await a pre-sentence investigation. Be done by probation and parole. And then I do not accept the Commonwealth's recommendation to decide to impose a harsher sentence after reading that. You have a right to withdraw your plea, go to trial. You understand that?
Yes.
Okay. Mr. Hunley, what is the Commonwealth's recommendation?
It's a guilty plea with a probation and drug court trial.
Go ahead.
Upon plea of guilty to possession of a controlled substance first degree, namely methamphetamine, the defendant shall receive a sentence of 3 years. This sentence shall run consecutively to Cumberland Circuit Court case number 20 CR 00064, which is a 3-year sentence, which will make this for a total of 6 years, probated for 5 years. The probation is to be supervised. The defendant agrees to continue his probation for 5 years in case number 20 00064. The defendant shall enter and complete the Cumberland Specialty Program. The defendant shall obtain gainful employment or do a minimum of 30 hours community service until such employment is obtained. And the defendant agrees that all evidence in these cases be destroyed in a manner consistent with the laws of the Commonwealth.
Is that what you agreed to?
Yes.
Are you pleading guilty because you committed the acts charged in the indictment as amended?
Yes, sir.
Due to your own free will?
Yes, sir.
Knowing your constitutional rights, as I've explained to you, is it still your desire to give up those rights, enter a plea of guilty and allow the court to fix your punishment?
Yes, sir.
Okay. You understand that after entering guilty plea, any future convictions could be enhanced under persistent felony offender law. You understand that?
Yes.
Is that your signature on the document? Yeah, I'll accept the agreement, order pre-sentence investigation report on January 22nd. And there wasn't a DUI in this, was there?
No, there wasn't, Your Honor.
Okay, we'll schedule your sentencing on January 22nd. I'm gonna let you remain free on your same body, not probation parole officer, okay? Do we have Caroline Hardison? Caroline Hardison. Commonwealth versus Carolina Hardison, 24 CR 0080. Are you Caroline Hardison? Good morning. Were you born in 1988? Last four digits, social security number 3232.
Yes, sir.
Represented by Mr. Lawless. Is that correct? What's the Commonwealth have to say in this case?
Is the verdict clear?
A motion has been filed today that says you wish to enter the plea. Is that correct?
Yes, sir.
Are you currently under the influence of drugs or alcohol? Is this plea freely and voluntarily given?
Yes.
Are you the same person that we just identified in 24 CR 0080?
Yes.
Is your judgment impaired today in any way?
Yes, sir.
Have you discussed the charges with your attorney? Are you satisfied with his advice?
Yes, sir.
Have you reviewed the evidence Commonwealth has against you? Believe you're fully informed about your case? Have you reviewed the evidence the Commonwealth has against you? Do you believe you're fully informed about your case?
I think I'm fully informed. I haven't personally reviewed evidence before.
Okay, well, we won't take a plea then. Just good. Next case is Commonwealth versus Robert Kelly.
We just,
Yeah, I skipped over that, yeah. Commonwealth versus James Craig.
Freaky.
Are you James Craigie? Is that how you say your name?
Yes, sir.
Good morning. This is 25 CR 0075. Mr. Craigie, were you born in 1969?
Yes, sir.
Last four digits, social security number 0295.
Yes.
Here today for the purpose of arraignment. You have a right to remain silent. You're represented by counsel. The grand jury of Cumberland County has returned an indictment charging you with trafficking in marijuana, possession of drug paraphernalia, and possession of marijuana. Do you understand those charges?
Yes, sir.
Mr. Bailiff? Counsel, you acknowledge the receipt indictment, the debt to your client, waive formal reading agreement, enter plea not guilty, reserving all pretrial motions.
Yes, Your Honor.
Sign a reciprocal discovery order, Mr. Creedy, that gives your attorney all the evidence the Commonwealth has to present to you to prepare for your defense. If you'll be here at January 16th at 9 a.m. for your negotiation day, and January 22nd is your next court date. Both of them are conditions of your bond, okay? Brian McGinnis.
Your Honor, I apologize. As for his bond, Mr. Craigie, sorry, is wondering if it could, he is on home incarceration without an ankle monitor, and he's fine with that. He was just wondering if he could be able to go to the store and maybe do a little Christmas shopping, if that was agreeable. He's had no violations.
Well, what you need to do, is Mr. Smith doing your monitoring?
No, it's just on pretrial monitoring.
He's
There's
got
no
an
ankle monitor.
No ankle bracelet? Well, you need to call pretrial and tell them that'll be okay. You go, don't be out gomming around, getting any trouble, but if you need to, 2 to 3 hour sessions to go shop, that'd be okay.
Thank you very much, Your Honor.
Okay, yeah. Brian McGinnis, active warrant out, Mr. Stockton.
There's a warrant out. Was that a direct submission or was that through the district coach?
Brian McGinnis.
I'm just wondering if he posted bond, but it's serious charges, it's trafficking.
You talking about Brian McGinnis? Well, there's an active warrant out for him.
Yeah, I wondered if he posted a bond district court. I just think about trying to get the bond though. Along with putting him in NCIC. Cause it, like I say, it's a serious case.
What's the story?
He didn't postpone. I think it might have been a 60-day order that might have released him.
What's he charged with?
He's possession of a handgun, convicted felon, trafficking, controlled substance, and PFO first. So maybe in our office's fault. I don't know why he wouldn't have indicted. I'll have to check into that.
Okay, you can put him in CIC.
Yes.
Jennifer Moore. Jennifer Moore, active warrant also
I think they're co-defendants.
in CIC. Ricky Purdue. Commonwealth versus Ricky Purdue, 25 CR 0067. Are you Ricky Purdue?
Sir.
Good morning. You born in 1961,
81.
1981. Last 4 digits, social security number 1284.
Yes, sir.
You're here for a pretrial conference. Suppose the Commonwealth have to say.
Your Honor, we have yet to receive a blood test from the lab, so we can get another pretrial.
What's the charge here?
1 endangerment, 1st degree, 2 counts, DUI.
You want to schedule it for next month,
Yeah, I'd like to schedule it for January if we could.
January 22nd.
And January
I
16th.
mean, have you you might as well do a negotiation.
Yes, that way we'll know if we've got the blood test back or not. We
Yeah.
can cancel it if we don't.
And negotiation day on January 16th here at 9 AM and next court date, January 22nd, 9 AM here. Both of them conditions your bond. I'll let you go free on your bond, okay?
Yes, sir.
Yes. Candace Simus, active warrant. Candace Simus, shocking.
We'll put her in CIC, Your Honor.
Okay, Wesley Smith. Wesley Smith. Commonwealth versus Wesley Smith, 24 CR 0072. Are you Wesley Smith?
Yes.
Good morning. Were you born in 1993?
Yes.
Last 4 digits, social security number 2348.
Yes.
This says for review, Mr. Stockton.
It's a forfeiture motion. I don't think we're going to get it.
We didn't agree to order on that.
Okay. I just didn't have a, it's a band.
To review the shock probation, see if he's doing what he's
Oh,
supposed to be doing. You got a job?
I'm supposed to start with Jake and Gingrich doing concrete work, and I have an interview for MK after the first of the
The
year.
answer is no. You do not have a job.
He's been trying to secure a job, Your Honor, and he's.
Well, I find that hard to believe. I mean, he might be after a position, but they can't hire anybody to do anything. When are you gonna have a job? I'm not talking about what you might do next spring or anything like that.
Supposed to start next week with the concrete job.
Next week would be Wednesday,
No, Monday.
Monday. Okay, well, I'm gonna believe you. Okay? We're not kidding about you working and meeting commitments here, because I tell you what, idle hands are the devil's workshop. If you have to have the discipline to come to work every day, and Mr. Gingrich will put you to work when you work for him, if you're working at concrete. So, you comply, and I'd like your attorney to confirm with the Commonwealth that you are in compliance, okay? Get it by letter by Wednesday of next week, just in case something happens on Monday, okay? Okay, thank you. Bernice Stearns. Bernice Stearns, Commonwealth versus Bernice Stearns, 25 CR 0068. Are you Bernice Stearns?
Yes, sir.
Were you born in 1982?
Yes, sir.
Last four digits, social security number 0513. You're here for a pretrial conference. What's the story here?
Felony plea, Your Honor.
Okay. I've just been informed that you have tendered a motion that says you wish to enter a plea today. Is that correct?
Yes, sir.
Are you currently under the influence of drugs or alcohol?
No, sir.
Is this plea freely and voluntarily given?
Yes, sir.
Are you the same person we just identified in 25 CR 0068?
Yes, sir.
Is your judgment impaired today in any way?
No, sir.
Have you discussed this matter with your attorney and are you satisfied with his advice?
Yes, sir.
Review the evidence Commonwealth has against you, believe you're fully informed about your case.
Yes, sir.
You understand that you do not have to enter a guilty plea. You have certain rights under Kentucky and the United States Constitution. Before I can accept you plead guilty, I need to know that you fully understand those rights. You have a right not to testify against yourself. No one can make you say anything, right to speak, trial by jury. The right to be represented by counsel at your jury trial, the right to confront and cross-examine all witnesses called to testify against you, the right to produce evidence, the right to call witnesses in your favor, and have process issued to compel their attendance. You have a right to appeal this matter to higher court if you lose, and the right to require the Commonwealth to prove your guilt beyond a reasonable doubt. You understand that by entering a plea today, you give up those rights. You understand that?
Yes, sir, I do.
Now, I may consider the Commonwealth's recommendation, but I may apply a range of sentences provided by law. If I don't accept the recommendation, after reviewing the pre-sentence investigation report, I will inform you and you will have an opportunity to withdraw your plea if I decide to give you a harsher penalty. You understand that?
I do understand, sir.
Mr. Stockton, what is the Commonwealth's recommendation?
It's plea of guilty to possession of controlled substance, first degree, 3 years, probated for 5, probation to be supervised. Also, she'll plead guilty to operating with no insurance, $500 fine. She will pay the $50 a month on the fine after her release from rehab. This is going to run consecutive to Cumberland Circuit Court Case number 19 CR 106. In lieu of revocation in 19106, the probation shall be extended for 5 years in that case. All evidence in this case will be destroyed. My understanding is she's in long-term treatment right now.
She is.
And she'll maintain that completely.
Where is she in long-term treatment?
Skyhope.
Okay, is that what you agreed to?
Yes, sir, it is.
Okay. Are you entering this plea because you did commit the acts charged in the indictment as amended?
Yes, sir, it
Doing
is.
so your own free will?
Yes, sir.
Knowing your constitutional rights explained to us is still your desire to give up those rights, enter plea guilty, not the court to fix your punishment. You understand that by entering a guilty plea today, any future convictions could be enhanced as a persistent felony offender.
Yes, sir, I do.
Is that your signature on the offer?
Yes, sir, it is.
Okay, I'll accept the agreement or pre-sentence investigation. Have you come back on January 22nd? Where are you working anywhere now?
No, I'm in rehab. They don't,
I know, but sometimes some of the rehabs allow you to work.
that's phase 2. I'm in phase 1.
Okay. Will you have work lined up when you get out or?
I do.
Okay, well, you need to meet with the probation and parole officer. I hope things turn around for you.
Thank you.
Cody Stinson, he's still
I'm still in U of L hospital. I like to file the little thing. So he's still.
okay. I don't really,
I've been trying, but 2 months ago, I got an update. And this time I just had a terrible time. I think I'd rather be sentenced to Siberian Gulag, just try to contact U of L hospital for information.
They are typical.
let me see her.
You go through their computerized phone system, never talk to a human being, so try Job's patience.
The only alternative is if we go ahead with the sentencing, I talked to Carson Payne, he says that as long as he's in the hospital out there, the corrections would have to take him back to the hospital. And they would have to hire somebody 24 hours a day to go out and sit with him at the hospital. And that's the reason I didn't want him to be final sentence, because I hate for the state to go to that kind of expense to watch him while he's in the hospital.
Have you been in contact with any of his family?
With his mother.
Well, you know, one of the things that picked the profile of this case is that there was a GoFundMe thing filed for a while and had a picture of him sitting up in the hospital, and evidently he's kind of nearly comatose. Is that
Well, when I was able to speak to Julia Pate up there, she told me, gave me details, and his condition worsened considerably after that. Now, I can't get in touch with anybody to know what his prognosis is. There's a Dr. Kumar I'm supposed to be able to talk to up there, but if I could ever get in touch with him, it'd be great, but.
Well, I suggest that we issue a subpoena for his attendance.
Well, I can do that for next court date.
Next court date. And if he decides that he doesn't want to honor that, then we'll know where to find him, and we might be able to agree to have him appear by Zoom,
That'd be good.
you know, just to get something on the record. Okay.
Thank you.
Thank you very much. Austin White. Good morning. Are you Austin White? Or this is 25 CR 0062. Are you born in 1999? Or the last four digits of your social security are 8022?
Sure.
What do you have here?
It's a motion to vacate the sentence that I entered on October the 2nd. I came to court that day with 5 felonies. They got dismissed for a misdemeanor, death by deception. And, I was trying to get that set aside based on the fact that I spent time in jail on a felony case. Didn't receive any credit for it.
What do you have to say?
Well, I thought his attorney and him did a good job in court. He was charged with theft of identity, and that probably wasn't the correct charge when the officer brought it, because he didn't have all the facts. He worked at a tire shop and allegedly used this gentleman's debit card.
Yeah.
And so we changed it from a felony to a misdemeanor. I thought he did quite well in the plea bargaining process and made restitution. He got credit for the time served. If he ever gets revoked on the misdemeanor, he'll get credit for it. So.
I don't really know what your basis to have it set aside is.
Or really, when I came to court that day, I told the public defender that I didn't want to enter a plea. I wanted to go to jury trial, and we stepped back out of the room back there, and we went back in the room 5 minutes later, and he said he thought it'd be in my best interest to do that, to take the plea. I didn't feel like it was, and still don't.
Well, I asked you all those questions.
I understand.
Okay, so there's really not anything I can do about it. So I'll enter an order denying your motion for 1142, and if you want to appeal that to higher court, you can. Okay,
Sure.
thank you very much. Yeah. Let's go down and take Mary Beth Stalker. She was here for the drug court. She's back there now. Commonwealth versus Mary Beth Stalker, 23 CR 0038 and 25 CR 0078 for arraignment on the second charge. Good morning. Stalker, you have a right to remain silent. The grand jury of Cumberland County has returned an indictment charging you with trafficking in controlled substance, first offense. Mr. Bailiff, counsel, you acknowledge the identity of your client, receive the indictment, waive formal reading and arraignment, enter plea of not guilty, reserving all pretrial motions.
Your Honor, yes, except we do have a resolution in her case today.
Okay, will you acknowledge her identity?
Yes, sir.
Does that change that, or the
No.
receipt of the indictment or waive formal reading and arraignment?
No, just the not guilty part is the only thing I had
Okay, well,
concern about.
is this an additional felony plea is what it's gonna be? A motion's been tendered that says you wish to enter a plea today, is that correct?
Yes.
Are you currently under the influence of drugs or alcohol?
No.
Is this plea freely and voluntarily given?
Yes,
Are you the same person that was identified
yes,
in 23 CR 0038, 25 CR 0078?
yes,
Is your judgment impaired?
no,
Have you discussed this matter with your attorney? Are you satisfied with his advice?
yes, sir.
Have you reviewed the evidence the Commonwealth has against you? Believe you're fully informed about your case?
Sure.
You understand that you do not have to enter a guilty plea, that you have certain rights under the Kentucky United States Constitution. I need to know that you understand those rights. I'm gonna go down through them. And when I finish, I'll ask you if you understand, okay? You have a right not to testify against yourself. No one can make you say anything, right to speak trial, but jury right to be represented in counsel in jury trial. Right to confront and cross-examine all witnesses called to testify against you, right to produce evidence, right to call witnesses in your favor, right to appeal this matter to higher court if you lose. Right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty of the charges against you. Understand that by entering a guilty plea, that you give up all those rights. You
Yes, sir.
understand? I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided below. I don't have to accept the recommendation. Prior to accepting any recommendation, I will wait to pre-sentence investigation report from probation and parole. In the event that I decide not to accept the recommendation and decide to impose a harsher sentence after having reviewed that report, you can withdraw your plea and go to trial. You understand?
Sir.
Mr. Hunley, would you give the Commonwealth's position on this?
Yes, Your Honor, upon a plea of guilty to possession of a controlled substance first degree, namely methamphetamine, the defendant shall receive a sentence of 2.5 years. This sentence shall run consecutive to Cumberland Circuit Court Case Number 23 CR 00038, a 5-year sentence for a total of 7.5 years. This shall be probated for 5 years. The probation is to be supervised. As part of the supervision, the defendant shall enter and complete the Cumberland Specialty Program. Defendant shall be released at orientation. Further, the defendant agrees to cooperate and testify in the case of Commonwealth versus Richard Whitlow. The defendant shall receive credit for time served, shall obtain gainful employment or do a minimum of 30 hours community service until gainful employment is obtained, and agrees that any evidence in this case be disposed of in a manner with the law of the Commonwealth.
So what you agree to?
Yes, sir.
Are you pleading guilty because you did commit the acts charged in the indictment as amended?
Yes, I did commit it, yes.
Knowing your constitutional rights, have explained to you, is it still your desire to give up those rights, enter a plea of guilty to the charges and allow the court to fix your punishment within range permitted by law?
Yes.
You understand that after entering this guilty plea, any future convictions could be enhanced as far as the range of penalties. You understand that?
Yes, sir.
Is that your signature on the document?
Yes, sir.
I accept the agreement order pre-sentence investigation report. You got the probation bureau. And we'll do the sentencing on January 22nd. I understand you're already down in the drug court. You already started, already been oriented.
Now, she's be oriented tomorrow morning if you want to release her. Yeah, it's beautiful.
You got somebody who's gonna, you got somebody to pick you up?
Yes, sir.
Well, I'll tell you, I'm gonna do something I don't usually do. I'm gonna go ahead and let you loose today.
Well,
Okay,
thank you.
and you can have, who's gonna pick you up?
Michael.
Okay. Now, have you already got some stuff up there at the jail, or you just want to donate to the cause up there?
Well, I mean, I got my clothes.
Okay, well,
Yeah.
they can transport you back up there and then your family can pick you up there, okay?
Thank you.
And we'll send the order up. Be careful tonight.
I will.
Unsupervised night, okay?
Thank you very much.
Okay, all right,
Thank you, y'all.
yeah.
Should be released from straight probation officer. If you release the straight probation officer.
Okay, we got the Adair County Jail on there. Rotor. Are y'all on there? Rotor Correction Complex. Okay, this is Commonwealth versus Scott Barlow. Are you Scott Barlow?
No,
Are you Robert Taylor? Tabor,
Yes.
rather? Well, let's do Tabor for Commonwealth versus Robert Tabor. 25 CR 0055. Mr. Tabor, were you born in 1987?
yes,
Last four digits, social security number 3597.
yes.
Okay, what do we have here?
Your Honor, Mr. Tabor has two cases. Allegedly, some of the acts occurred here in Cumberland County and Monroe County. He's been indicted in both counties. Candace Hill represents him in Monroe County. There's quite a bit of investigation she wants to do, and I think we did by agreed order. We passed this out till March. And so if you want to do that,
What are the charges?
rape first degree with a minor child.
Okay.
So
Is that what counsel that?
Yes, Your Honor.
he's serving a 9-year sentence right now.
March 24th. The next court date's March 24th.
Thank you.
Okay, is Mr. Scott Barlow there?
Okay, am I done, Your Honor?
You're done. Yes, sir.
Okay, thank you.
Merry Christmas to you.
Merry Christmas.
Yeah. Scott Barlow there at Rotor, evidently not. So we lost Rotor there. So,
I think typically they have different case managers, so one may not know that the other is on.
okay, well. I don't know that anybody's on either, so.
You're not too good about getting people on that for shot probation.
Well, I'll pass on that. And there's about 8 minutes till we go to the Dare County Jail, is that correct? Yes, authorized.
you know, that.
Well, if you have any additional evidence, you might give it to the Commonwealth. They might change their plea offer.
I wish I had.
Okay. Are you Carolyn Hardison? Is that correct?
Yes, sir.
This is 24 CR 0080. We're born in 1988.
Yes, sir.
That's 4 digits, social security number 3232. A motion has been tendered that says you wish to enter guilty plea today. Is that correct?
Yes, sir.
Are you currently under the influence of drugs or alcohol?
Yes, sir.
Is this plea freely and voluntarily given?
Yes.
Are you the same person that we identified twice in 24 CR 0080?
Yes, sir.
Is your judgment impaired today in any way?
No, sir.
Have you discussed these charges with your attorney? Are you satisfied with his advice?
Yes, sir.
Have you reviewed the evidence that the Commonwealth has against you?
Yes, sir.
Do you believe you're fully informed about your case? You understand that you do not have to enter a guilty plea. You have certain rights under the Kentucky United States Constitution. Before I can proceed, I need to know that you understand those rights. You have a right not to testify against yourself. No one can make you say the right to speak trial, but jury right to be represented by counsel at your jury trial, the right to confront and cross-examine all witnesses, call testify, to produce evidence, the right to call witnesses in your favor, and have process issued to compel their attendance, the right to appeal this matter to higher court if you lose, and right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty of charges against you. And by entering a plea, you give up all those rights. Now, you understand that?
Yes, sir.
I may consider the Commonwealth's recommendation, but I may apply any range of sentence by the law. I do not have to give the recommendation. Now, Mr. Hunley, will you go ahead and give what the recommendation is?
Yes, Your Honor. Upon a plea of guilty to willfully allowing a buyer to escape from her own land to another, the defendant shall receive a sentence of 1 year. Pretrial diverted to 1 year. The land in question is adjacent to the land of Donald Abney. The defendant agrees to convey deed her land to the victim, Donald Abney, as restitution. The defendant is to pay all property taxes on the land and deed preparation.
Is that what you agree to?
Yes, sir.
Now, let me go over this, some qualifications. Have you previously been diverted in the last 5 years?
No, sir.
You had any felonies in the past 10 years?
No, sir.
Currently on probation?
No, sir.
You understand if you fully complete the diversion program, the charges will be dismissed, pretrial diverted. You can have your record expunged. You
Yes, sir.
understand that? But if you do not successfully complete the diversion program and you're brought back in front of me for a violation, the court will schedule a sentencing hearing. You would be a convicted felon. And that can be used against you in the future. You understand that?
Yes, sir.
Are you pleading guilty because you did commit the acts charged in the indictment as amended now?
Yes, sir.
You do so of your own free will.
Yes, sir.
Your constitutional rights explain to you is still your desire to give up those rights, enter a plea of guilty to the charges and allow the court to fix your punishment. Is that your signature on the document? You have the document there?
Yes, sir.
I'll accept the agreement. What are the court costs in this case?
$240.
Court costs are $240. Can you pay them today or do you need some time? I can do it monthly if you want to. Does that help you any? $240?
I could pay it today, but I wouldn't have money to work.
Well,
Like, can I pay
what I'm
it
gonna
over
do
the,
is
can I
I'm gonna
pay
let
it in
you-
the next 30 days?
I'm gonna do you a better deal in that you pay the first $30, 30 days from today, and every 30 days after that, you pay $30, which should be about, 8 months, spread it out. Help you any?
Yes, sir.
Okay, well, the probation and parole officer is back there. You'll need to talk to her. Okay, thank you. Okay, I guess we can go off the record till 10:30. Is that correct? Do what? And Dare County, are you all ready to proceed with your docket?
Yes, sir.
Okay, well, we'll go ahead and take it up then. Is Commonwealth ready?
Yeah.
Let's see Timothy Alexander. Mr. Poindexter is not here yet. Will,
I represent.
you're on the case now, DPA is?
Yes.
Okay, Commonwealth of Kentucky versus Timothy Alexander, 23 CR 0039. Are you Timothy Alexander?
Sir.
Born in 1982.
Yes, sir.
Last four digits, social security number 5227.
Yes, sir.
So probation revocation, what does the Commonwealth have to say?
Yeah, there's a new case going before the grand jury this morning.
Please speak up.
There's a new case going before the grand jury this morning. I anticipate an indictment, so I just asked that this be continued to January, and the negotiation day in January.
The negotiation date will be set for January the 16th. The next court date will be January 22nd by agreement. Okay? Thank you very much. William Brooks, your attorney will be up to see you. William Brooks.
Hey, Tim, just have a seat for now.
Oh, I'm gonna take it.
Are you William Brooks?
Yes, sir.
Good morning.
Good morning.
This is 25 CR 005 and 25 0065. Mr. Brooks, were you born in 1983?
Yes, sir.
Last four digits, social security number 7291.
Yes, sir.
What's the Commonwealth have to say?
Felony plea, Your Honor.
Mr. Brooks, I'm just informed that you have filed a motion that says you wish to enter a plea today. Is that correct?
Yes, sir.
You're currently under the influence of drugs or alcohol.
No, sir.
Will you freely and voluntarily give it?
Yes, sir.
Are you the same person that we just named in 25 CR 005 and 25 CR 0065?
Yes, sir.
Have you discussed this matter with your attorney? Are you satisfied with his advice?
Yes, sir.
Have you reviewed the evidence the Commonwealth has against you? Feel like you're fully informed about the case?
Yes,
You
sir.
have certain rights under the Kentucky United States Constitution. You do not have to enter a guilty plea. And before I can accept a plea, I need to know that you understand those rights. I'm gonna go over them at the end. I'm gonna ask you to understand. If you have a right not to testify against yourself, no one can do the same thing, right to speak trial, but jury right to be represented by counsel at your jury trial, the right to confront and cross-examine all witnesses called to testify against you. Right to produce evidence, right to call witnesses in your favor, the right to close this matter to higher court if you lose. The right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty charge against you. Understand that by entering a guilty plea, they give up all those rights. You understand that? Now, I may consider the Commonwealth's recommendation, but I'm now playing a range of sentence by the law. I don't have to accept, prior to accepting the recommendation. I will order a pre-sentence investigation report to be done by probation and parole. Then after viewing that report, I decided not to accept the recommendation, give you a harsher sentence. You have the right to withdraw your plea, proceed to trial. You understand that?
Yes, sir.
Mr. Stockton, what's the Commonwealth's recommendation?
Your Honor, the defendant agrees to stipulate revocation in Cumberland indictment number 25 CR 5 upon a plea of guilty to theft unlawful taking. In this case, over $1,000, he'll receive a sentence of 1 year to serve. 1 year shall run consecutively to Cumberland Circuit Indictment 25 CR 5. The Commonwealth opposes probation, and I probably will not oppose shock probation after he serves 4 or 5 months. He was in the special report program. He never got started because he was in a car accident and he committed this new felony. So I might look at putting him back in the drug court in 4 or 5 months.
Is that your understanding of the Commonwealth's recommendation?
Yes, sir.
Okay. Are you pleading guilty because you committed the acts charged in the indictment as amendment?
Yes, sir.
Is of your own free will? Knowing your
Yes, sir.
constitutional rights have explained to you still your desire to proceed with your plea and to allow the court to fix your punishment within the range of the law. Is that correct?
Yes, sir.
And you understand that after any of this guilty plea, any future convictions could be enhanced as far as the range of penalty.
Yes, sir.
Mr. Bailiff, will you retrieve the document here and let this gentleman hand it up here and I'll show him that signature. Sir, is that your signature on there?
Yes, sir.
Well, I'll accept the agreement. Order pre-sentence investigation report to be done by probation and parole. Schedule sentencing for January the 22nd.
Thank you.
Okay, thank you. Alfred Cresilius. Alfred Cresilius.
Ready whenever you want.
Okay. Are you Alfred Cresilius?
Yes, sir.
Good morning.
Good morning.
This is 25 CR 0052. Mr. Cresilius, were you born in 1985?
Yes, sir.
Last four digits, social security number 5305.
Yes, sir.
We're here for review, it says, and because we didn't have a DUI guilty plea form filled out, do you have it now?
Yes, Your Honor.
Commonwealth, have you seen it?
Yes,
Okay, well, is that all we need with Mr. Cresilius?
yes.
Okay, we got the form in, Mr. Cresilius, so that's all we need. Merry Christmas to you.
All right, thank you. Merry Christmas to you.
Barry Gibson. Barry Gibson. Barry Gibson.
It'll be good.
Yes, sir.
22 CR 0037. Are you Barry Gibson?
Yes, sir.
Well, good morning. Were you
Good morning.
born in 1969.
Yes, sir.
Last four digits, social security are 9632. We're
Yes,
here
sir.
on the pre-trial diversion revocation. What's the Commonwealth have?
Your Honor, he's got a 5-year sentence on one endangerment first, and he's agreeing to stipulate on this.
Okay, you stipulating on the revocation, I order a pre-sentence investigation for it to be done by probation and parole. Probation
Yes,
and
sir.
parole will be up to see you pretty soon to interview, okay?
Yes, sir.
Okay, Merry Christmas to you.
Merry Christmas.
Aaron Lee. Raymond. 25 CR 0077. Are you Aaron Lee?
Yeah.
Good morning.
Good morning.
Born in 1994, Mr. Lee,
Yes.
and the last four digits, social security number 1623. Here
Yes.
for the purpose of arraignment. You have the right to remain silent. Office of Public Advocacy represents you. Public Defender's Office. Do we have a form on this? Yeah, the EPA and district court, so I'll continue the appointment. You have a right to remain silent. The grand jury has charged you with possession of controlled substance, first degree methamphetamine, possession of drug paraphernalia, and possession of controlled substance not in the original contained. Counsel, you acknowledge the identity of your client, receive indictment, waive formal reading and arraignment, enter plea not guilty or other non-pretrial motions.
Yes, Your
I'm
Honor.
signing a reciprocal discovery order, sir, that will require the Commonwealth to give your attorney available information to prepare for your defense. We will schedule a negotiation day on January 16th, and the next court day is on January 22nd. Okay?
Your Honor, if I could inquire about his bond, I don't see one set, so I just want to.
I can't hear you, I'm sorry.
He's got 25 minutes on the pocket, that case.
Was it a clerk approved surety?
We originally had 15,000 surety here in your court, and it was amended to nobody to say 11.
That's what this just.
Do what?
You got the new case.
Yeah.
So there's a
He was out on
pending
bond.
evidence.
He was out on bond, and he pulled another case.
Your Honor, I would ask the
Well,
court.
I'm still not aware of what's going on. What's his other charge? He just got arraignment on here and they don't have another charge. Was he out on bond on a different charge or what? I don't want to look at it. I just want you to tell me.
Yeah. Personal recon. This case, what we're going with. And, yeah, it looks like you got indicted. And we've got this new case on the. Yeah.
Did he get a new case when he was arrested, Andy?
He did.
Okay. That's what he got a new case.
So when they arrested him, they
He got a new
found
possession.
something on him. Right.
Yeah, in that case, it's not going to the grand jury today, so the new case will probably be next month.
Is it a possession case?
Another possession case, yes. So he's got two possession cases.
So he was under bond in the district court when he caught this second charge, or did it
Well,
was
no,
just
I
a
guess-
direct submission?
I guess what happened was when they went to serve an indictment warrant, you had a bond on the indictment warrant.
I'm asking though if he was under a bond in the district court or it was.
He should have been, it was a F case.
ROR. So here we got him out ROR on a possession case and they serve it on him, the indictment warrant, and they catch him again. So
Yeah.
that's the reason I put no bond.
Your Honor, I heard that there was a cash bond on the pending F case. Would the court consider a concurrent cash
There
bond?
was an ROR
On the new one, I apologize, on the new F case.
I didn't have, no, I held it with no bond because he was arrested, he was out on an ROR for possession of drugs. They arrested him, he's out on bond, they arrested him, he got drugs on him again.
Understand, Your Honor.
I do not like that.
Understand.
What does the Commonwealth have to say about it?
That's fine. This is good time, I would think. He's got an 18 case criminal history, so it's not like he's new to the system.
Yeah.
We can handle it on negotiation day probably.
Negotiation day, the 16th. And the next court date's on the 22nd, and on the 16th, if y'all can reach some agreement as to bond, I'll consider it, okay?
Thank you, Your
Thank you
Honor.
very much. Thank you, Mr. Lee. Yes.
What? This also a problem, there's $2,500 cash bond, say it on the F case, the new judge, the new case, that's good, it's all six. I think that's what she named it to all.
Well, I'm getting two different things here. I don't know.
That's just what Megan told me to do.
Do what?
That's what Megan asked me to do.
Yeah. Well, the clerks tell me something different here, so, but I'm holding without, I'm holding to that day anyway, okay?
But in this case that we currently have was just an F case before it got to us, he was ROR.
Yeah.
He was indicted, you said, the surety bond on indictment. When he went to serve the indictment warrant, he had drugs on him. He was arrested on that F case, and she said a $2,500 cash bond on that case. So he has the cash bond on that F case, and then no bond on the CF case. So that's what she's talking about. So he does have a cash bond on the F case. The new F case.
I don't have the.
Yeah, correct.
That's in that mortgage degree. Thomas O'Donnell.
That's just our motions, and we probably shouldn't have put them on the docket. That's all the out-of-state witnesses we need to get. served.
Mr. O'Donnell, are you representing Mr. O'Donnell?
Well, I'm on his team, Your Honor, so I'll say
Well,
it in.
okay,
I
well,
wasn't.
the only thing this is a motion to secure orders for out-of-state witnesses. You have-
Multiple motions, yes.
Pardon?
Multiple.
Multiple motions to secure. You have no objection to that.
For the subpoenas, I don't believe so, Your Honor.
Well,
I
mean,
think
you
it was
need to- You don't
filed.
believe so. Tell me, what do you believe? Do you have objections or no objections?
I don't think so, Your Honor, because
You
this is
don't
my.
think so, you don't believe and you don't think.
Hey, let me explain, Your Honor.
I'm asking you to think and to believe.
So today is my first day back.
Congratulations.
Yes.
You agreed just to the subpoenas.
I believe we are all in agreement to subpoenas.
Well, I can't accept that.
Your Honor, I apologize.
I don't want your apology, I want your agreement. These are just subpoenas. I'm gonna, and you not stated a cogent objection to it. I'm gonna go ahead and approve the subpoenas. Okay?
Okay, Your Honor.
Thank you, Mr. O'Donnell. We're finished. Gene Parrish. Are you Gene Parrish?
Yes, sir.
Good morning. This
Good
is
morning, how you doing?
25 CR 00011. Were you born in 1989, Mr. Parrish?
Yes, sir.
Last four digits, social security number 9523.
Yep.
This is the probation revocation. What does the Commonwealth have to say?
Your Honor, he has a 3-year sentence on possession. And it looks like since October the 13th of 2025, he's had nothing but problems. Failed the drug test, failed a report, failed to complete treatment. I'm prepared to put Mr.
stipulate to these?
We're stipulating, Your Honor.
Stipulate, I think it would be better, Mr. Parrish, for me to revoke his probation and try to get, the parole board to act on it rather than obviously cannot comply with probation. Good luck to you, Mr. Parrish. Merry Christmas. Okay. Richard Whitlow for arraignment. This is the last case for the grand jury. Mr. Richard Whitlow. Are you Richard Whitlow?
Yes, sir.
Hello, you're here today on 25 CR 0079 for arraignment. Were you born in 1975, Mr. Whitlow?
Yes, sir.
Okay, last four digits, social security number 7638, is that correct?
No,
7630, what are the last four digits of social security number? The last four digits of your social security number,
of my social security number,
your social security number.
0884.
There should be four numbers. That are the last four digits.
0884.
0884. Okay. Well, we'll make that correction. Sorry, you have a right to remain silent. The grand jury of Cumberland County has returned an indictment charging you with trafficking, controlled substance, first degree, second offense, being a persistent felony offender. Mr. Bailey? Mr. Whitlow, you understand what those charges are. I'm not asking if you're guilty.
No, sir, I don't.
You don't? Okay,
No,
well,
I'd
I'll
like-
read the indictment to you. Here. Give me the indictment back. The grand jury of Cumberland County charges that on or about the 30th day of October 2025, above named defendant committed the offense of trafficking in controlled substance, first degree, second offense, over 2 grams, a class B felony, when the defendant knowingly and unlawfully sold, transferred, distributed, dispensed, or possessed methamphetamine with the intent to distribute said methamphetamine against the peace and dignity of the Commonwealth of Kentucky, signed as a true bill by the former of the grand jury, and being a persistent felony offender means that the grand jury finds that on or about October 30th, 2025 in Cumberland County, Kentucky, the above named defendant committed the offense of trafficking controlled substance, first degree, second offense, over 2 grams. And at that time, the defendant was a person more than 21 years of age who stood convicted of a prior felony offense, with the previous conviction being conviction of a felony in this state or convicted of a crime in any other jurisdiction, and the sentence and then a sentence of term of imprisonment of 1 year or more was imposed. Defendant and the defendant was over the age of 18 at the time the offense was committed. The defendant completed the service of sentence imposed on previous felony conviction within 5 years of the date of commission of the previous felony conviction. Within 5 years of the date of commission of felony of trafficking controlled substance, first degree. Or the defendant was on probation, parole, conditional discharge, furlough, appeal, some other legal form of release on the conviction on October 25th, 2025. Signed a true bill against the peace of the Commonwealth of Kentucky. You acknowledge, we formally read the indictment, you acknowledge the identity, you have a plea to enter on,
And plea of not guilty to the charge.
reserving all pretrial motions.
Yes, Your Honor.
I'm signing a
I'd like to put in
receipt.
for a change of venue.
Well, you'll have an
Your Honor.
opportunity to talk to your attorney about that.
There's clear conflict in this case, in
You
this
need to be
court.
quiet right now. Okay, your attorney will get an opportunity to talk to you about that. Thank you. Okay, now we'll schedule a January 16th negotiation day, and January the 22nd, and your attorney will be able to come up to talk to you, Mr. Whitlow, about any kind of motions you want to file, okay? Is there anybody else in Daris County we need to talk to?
No, we're done, Judge. Thank you.
Okay, thank you. I'll make you excused. Okay, does that complete the criminal docket? Okay, let's go off the record here, I guess. Come over here and do this.
Okay, to bring the grand jury in now.
Yeah, let's stay on the record for the grand jury. I've got to bring the grand jury in to turn them off on this, turn them off on the The Eagle has landed, so we can start the case. Monroe Circuit Court Case 21 CI 00015 Hamilton versus Harlow. Is that correct? You want to come around?
Yes, Your Honor, Kelly Lester.
Now, I read your motions here and you have several of them, I guess. Have you come to any accord on any of them? Or you just want to go down through the list with them?
We have agreed,
I was gonna say, there was one that had a lot of motions. I think she agreed to every one of them.
Yeah, I saw that. It
There are
looked like
two that
it.
are at issue. Actually, they're basically.
You need to speak up and talk into the, be right behind the directional microphone.
Seems that there are two motions that are intertwined, that are still left. Dr. Timoney's testimony regarding the possible surgery, and then Laura Lambton, the life.
That's
care
the
plan.
40% possibility of similarly situated people having that sort of thing.
Yes, Your Honor.
Well, I haven't ever practiced a case where they had like 40% probability of somebody having somebody. If I had a 40% probability because of this thing, is that a jury question to see whether or not, that is medical testimony can establish that with some sort of, the words certainty and probability and possibility don't mean all the same thing, Tell
Our
me
case
about
law
that.
is.
Pardon?
Our case law is pretty well put together that says there are no magic words that you have to say, but possible is not enough. And I think in our reply, what we pointed to was her jury instruction, which says, what are the medical expenses that he has reasonably.
You're gonna have to speak up into the microphone. The
Sorry.
acoustic's not good here.
We pointed to the jury instruction for future medical.
Yeah.
And what it says is to provide him for medicals that you are reasonably certain that he is to incur in the future. You cannot be reasonably certain that a possibility is going to occur. By definition, it is
What do
the
you think
exact
that's to be
opposite.
51% of people that do that to be reasonably certain, or what? Let's say if the doctor testified, 51% of the people who have this procedure have this other problem later. Is that what it
Absolutely,
takes?
that's more probable than not. That's the standard. And yes, I understand.
Well,
when you look
that's
at-
more, well, it's
we look
more
at it this
probable.
way.
If you look at the general population, that's more probable than not. But if you look at someone that has this procedure, they're more probable to have that than somebody in the general population.
I agree with Dr. Timoney, despite there's disagreement in the field, that she believes, based on what she's read, that there is a 40% increase in likelihood of a surgery within 5 years. That is not probability, that is a possibility, and that is for people who have had it surgery. So it doesn't get to probability.
Wouldn't the 40% be a probability instead of a possibility?
Say that one more time.
Well, wouldn't the 40% be a probability if you just dealt with possibilities? It's 100% possible.
Everything's
Anything can
100%
happen.
possible.
Everything's 100% possible. So then you have more probable than not. I don't know. What do you have to say about it? Do you feel like his case law is as solid as he does?
I feel like the case law is solid in the case Cincinnati Insurance versus Samples. And in that case, the physician testified that 15 to 20% of his patients with injuries similar to those suffered by Samples will need future surgery. And the the Kentucky Supreme Court found that that was sufficient to support an award of future medical expenses. The case law is clear. I asked this question in all of my medical doctor testimony, is that are they at an increased likelihood of some future surgery because of the surgery that they received?
Versus the general population.
Versus the general population. And that is enough for the jury to weigh whether or not they believe that they should award Mr. Hamilton expenses for future medical
Well, I
treatment.
might be wrong on that. I could very well, but that's what I'm gonna go with, and you can, I guess if we make it to a jury, you can argue that to the jury. And that's something that the fact finder will have to determine, because I don't know if you don't do that. I think the jural rights of the individual to cover from this, injury would be limited because they can't come back and get the second bite of the apple.
Exactly.
If those years, so I'm gonna allow a testimony about that. And what was the other thing that wasn't agreed to?
The other one that's not exactly intertwined is Laura Lambton's testimony regarding household services. I think, and I'm still confused because the trial brief says they have 117,000 in future medicals.
I can't hear you. I'm sorry. You have
I
to lean
apologize.
toward that microphone. Okay,
Get in
lean,
her
the one
way.
right in
It's
front of you.
okay.
The one that's red there.
Yes.
Okay.
Their trial brief includes a request for $117,000 in future medicals. That is identical to the number that Ms. Lampton included for household services, basically help he would need because of limitations he has in activities of daily living over the rest of his life. My problem with her testifying regarding those damages is she has decided that the restrictions, which are not testified to by Dr. Timoney in any fashion, were caused by this accident. She has made a causal relationship to this accident, which is the sole province of a medical doctor.
I have a problem with that. I really have a problem with that. It might be that you have to open depositions back up, you know, I don't think that she's qualified to do that. Have you used her to make this causal thing before?
I have, Judge, and she's actually testified to this exact thing in 168 cases in the state of Kentucky, and it's never been appealed. She has testified in probably 5 jury trials for me, and how she makes that is she speaks to Mr. Hamilton. She is certified as a life care planner, and she projects those costs based on 2 things: Dr. Timoney's medical records and testimony, and speaking to Mr. Hamilton. Now, Mr. Hughes can
Now,
cross-examine.
did you attach that portion of the deposition where she was doing that? Because I think you'd have to have a pretty strong correlation between that medical evidence, and then she could apply that as someone who is a rehabilitation expert, which I don't know about her certification here. I mean, under a Daubert sort of situation.
She's a certified nurse. I don't believe that certification is the issue, and I don't want to make that the issue. The issue is Dr. Timoney, when asked about
You
future
need to get
medical
behind
expenses.
there's something, are you adverse to red or something like that?
I think so.
Okay, just calm down. We got plenty of time here. Okay, I talk and think slower than judges you're used to. Okay, go ahead.
When we took Dr. Timoney's deposition, which was several years ago, I asked her whether or not she foresaw any future medical treatment.
This is the nurse you're talking about.
No, this is the doctor, Dr. Timoney. If there was.
I didn't know Dr. Timoney was a she when you said the she. Okay.
Yes. I asked her whether there was any future treatment needs for Mr. Hamilton.
Yeah.
And she said no. She did not testify to any restrictions that he had. She didn't testify to any limitations he had.
Yeah.
So there's just a lack of a basis.
Well, that's what I was saying, that I didn't see anything for is she a PhD nurse, the rehabilitation nurse? I didn't see direct correlation into what she would, from what I've seen at this point, what she says to any evidence that there was going to be a need. And that's problematic for me. You understand why that would be problematic?
Completely understand your position, Your Honor. She is actually a certified life care planner, and her CV is attached, and if we have not.
Yeah, but the problem is whether or not, after she talks to him, his limitations, where you can connect that to the injury that was suffered in this case. That's the causal problem I have. And I think there's a gap there. And, you know, if you need some time to go back and redepose somebody or something, I understand that. But right now, I'm not inclined to allow her testimony.
And what we would ask is that we proffer her before she's able to testify, even in front of the jury, so that we can do, or we can do it in a deposition, however the court would prefer. She's going to come testify, obviously, to the amount of medicals that you allow her to do that. But what we could do is question her for 15 minutes, even prior to, not in the presence of the jury. I've had some
That way
judges
you preserve it.
do that, right, and preserve that issue. And she is happy to testify to this court how she is able to connect the nexus and the qualifications, the certifications, the training, the scientific knowledge, and all that
I
she
don't
has.
think that she can convince me that what she sees in this patient was caused by this accident, unless the medical professional that saw this fella and treated the plaintiff establishes that. I mean, she only views what she sees. I guess she could ask him, well, you weren't like this before the wreck, were you? I mean, that's kind of like where somebody's presumptively Medicaid eligible. They come to the hospital, they'll say, well, if you don't make over $55,000, you get free insurance. You know what I'm saying?
And let me just add one more thing, Judge.
Okay.
Some of those household services are related if he has to get that second fusion surgery, because of the fusion that he had as a result of this injury. There will be some rehabilitation period after
So he's one of the 40% that has to have other surgery because they had this first fusion?
Well, that's what the life care plan essentially says, and we have, I mean, he only gets one bite at the apple. If the,
Well, I know the life care plan says that, but is there a physician that says that he's got to have another surgery?
well, that's what Dr. Timoney's testimony was with regards adjacent level disc disease. She testifies to this. Let me back up and she
Is
testifies.
that the 40%?
Yes, if he develops adjacent level disc disease.
Okay, now that, I understand that, and I'm following you, but do we have a doctor that says that he has developed that, a physician that says he has developed that? Because if you do have a physician that developed that, then that physician would open up the testimony of the rehab person, as far as I'm concerned.
Well, Dr. Timoney specifically testifies to the treatment that he will need
If he develops.
if he develops it.
Who has testified that he has developed?
Well, I've asked her, going back to adjacent level disc disease, without a doubt, you can testify that he's at an increased risk for adjacent level disc disease. Is that correct? And she says
No,
that
I'm
is
talking
correct.
about who can testify that he has developed that. I've already let you get the risk in there. But now we're talking about the rehab course of future rehab course, cost. So I'm not gonna let him, if you get there, I mean, you says that he has developed that, okay? So what you're saying is if he does develop that, then this is what the cost would be.
And the jury has to determine, based on the evidence, if they feel he is going to develop it. And if they find that he does, this is the future amount of medical bills that he would need to get the fusion, and she testifies everything that he will need if he
happens.
develops that, yeah. And he's still,
You got something to say?
The only thing I would say is the two issues, the household services and the medical, what I would call actual medical costs, I see as separate. There is testimony if you allow her to testify regarding the possibility, which we object to.
Yeah.
But if she does testify to that, then Ms. Lampton can testify to the cost that would be associated with
With
that.
medical.
I just don't think she can talk about the household services because there is no evidence that he's going to need that, or more importantly, that it's related to this accident.
Or if he had some kind of corrective surgery, that he still wouldn't need the household stuff after that.
And
Is that what you're saying?
yes, Mr. Hamilton's is a little bit of an unusual situation. After this accident, before his surgery, he had a brain surgery for a tremor, which caused some balance problems. He also has polyneuropathy, which has required the amputation of a part of his foot. He has a lot of other issues.
Yeah,
So
well, here's what I'm gonna rule. I'm gonna allow her to testify about the probability, but I'm not gonna allow any of this household stuff. Okay, I'm not gonna allow the household. I mean, they can do conjecture on what the medical care and cost would be, but not the household stuff, because there's no way, we haven't given a percentage of how many people would recover from that second surgery and what household stuff they need. So that would be my ruling for you, John. Is there anything else?
I think that,
one question based on your ruling, Your Honor, their pretrial brief, and Ms. Lester can tell me if I'm incorrect. The only damages I think they requested were the $117,000 in household expenses. I think that probably needs to be updated if they're going to include the cost of the surgery and the physical therapy.
so Lampton's life care plan was around 300 and,
I agree. Your trial brief just didn't include those things.
What he's saying is modify the trial.
we'll modify it based on the
to-
court's ruling.
Okay.
Show it.
Okay, we'll
That'd be
modify it based on the court's ruling. Now, there was one last issue that I think you want to bring up about the length of the trial. Are you
Oh.
prepared to?
I think 2 days is going to be. We have to do everything perfectly to get through in 2 days. When we initially came before the court.
You're
and
looking at
asked for
Mr.
dates,
Perfect.
I haven't been to a perfect. There's 12
If
people
y'all
in the
take
box,
off for
so-
lunch or what do you do, If y'all mediate it and work,
We
right?
mediated it. I think we can get it done in 2 days. He thinks we can't. I don't want to continue the
Well,
trial.
what we'll do is, what days are that on there?
It's Thursday, Friday, and I asked.
February 5th and 6th. If that last day wasn't a Friday and we wouldn't have to come back on Monday, I have a witness
You
coming.
don't work on Saturday?
I do. I'm not sure my witness will. Nor do I really want the jury to.
Well, I'm sure that that is, Well, if we did, if we did jury selection and some of that sort of stuff on the fourth,
Be great.
you know, and that way out of abundance of caution, and if you had some witnesses that would be available on the fourth, we might finish on the fifth. If we don't, that'd get the sixth. I think that.
The only problem I have there is when I'm gonna get my expert here. If he's gonna go on the second day, that's fine. I just kind of need to know.
I'm not gonna make you put him on the first day.
Okay.
You know, and if you tell me on the fourth that the order of witnesses would not be conducive to a good presentation, then we'll wait and do it on the fifth. Okay? Seating the jury, you know, we can do that.
I have one witness.
You got one witness.
I have one witness.
Well, I don't see any reason why we couldn't come in at like noon on the fourth then. What do you think about that?
Do openings and then start full on Thursday. That'd be great.
Now, is the fourth, the Thursday or
It's a
Wednesday?
Wednesday.
Wednesday. So you're saying pick the jury, be prepared for openings on Wednesday and then rock and roll on Thursday.
And
Okay.
Friday if necessary.
Yeah. I can say on Saturday too,
You know,
whatever,
won't
whatever
do it.
we need
We're
to
not
get
gonna
this
do it on
case done.
Saturday, no.
It's been on this docket for a very long time,
Just
so.
kidding.
Happy to get it done that way.
See here. Okay, we'll do it. You want to do it at noon or should we just come in? I think it would be better if we came in at noon to do that. Because that way the jury wouldn't tarry and be tired and that sort of thing and wonder why we're not proceeding.
I think that's fine.
Okay. Does y'all anticipate any other pretrial things or?
Not at this time, no.
Now, two questions for your court, because I want to do things the way that this court does them.
We don't try civil cases. This will be the first civil case we tried in 14 years.
I know, well, so in terms of objections, do you want us to object and state our objection from the jury? Or do you want us to
I
approach
want
the
you to
bench?
object and approach.
Okay, in terms of jury selection and picking the jury and going through questioning. Typically, how I do it is I go through a series of questions and any strikes that I have for calls, I'll approach the bench then and then.
Well, I have a tendency to do some voir dire myself.
Okay,
Okay, I'll do that and then let you supplement it
okay,
as you try to influence the jury through your questions.
We would never do that.
No, I know, but there's some that do. And so, but if you have anything for calls, you could approach at that time. And if you have anything that you'd like to ask the other jurors out of the presence, you know, this courtroom is hard to do that in, but over in Monroe County, it's easier. I mean, there's more distance over there and their button works a little bit better. But if you have some lengthy sort of thing, that's the way we do it. Is there anything else?
will you allow us to get the juror forms and the jury list prior, because I would imagine,
They're just new and you can get them.
okay,
Now,
You can get them now.
Great.
And of course, you know, don't put them in on Twitter or anything, you know, or whatever. Just you keep them, and I trust members of our to look at that. And we have a robust turnout over there. I think we had 100 maybe people. And so you can get those now. Okay, is there anything else?
I thought I could think of your arm. I appreciate it.
We'll see you in
I surely
February.
won't think of anything else. Okay, Merry Christmas,
Merry
Smoker.
Christmas. Thank you, Judge. Merry Christmas.
Thank you for coming over here.
No problem.
Okay. Oh. Okay. Riddle versus Collins.
Good afternoon, Judge. Attorney Tim Hendricks for Ms. Collins.
Let me try to find this. It's gonna. Okay. This is a motion concerning the first issue is the cancellation of Kentucky K-chip, I guess it's called, and what's the explanation for that?
Judge, my understanding is that Ms. Collins does not reside
You're gonna
in
have to look
Kentucky.
toward, you're gonna have to look, I can't hear you. You're gonna have to turn it up or something.
Sorry, Judge, my understanding is that Ms. Collins no longer resides in Kentucky. She has moved, she's lived in Tennessee for several years. And so when she applies for those type of things, she has to do it in Tennessee. My understanding is she did not request that they transfer for the child for his card to go to Tennessee, but that's just simply what they did when she had to update her information a couple years ago. My understanding is this card change has been in effect for several years.
You're gonna have to, I'm gonna have to get some earphones or something. I can't, you give me some earphones. Can you hear what he's saying out there?
I cannot, Judge.
Okay, we'll get some earphones out there. Now try to say something.
Yes, sir. Maybe that'll cut down on the echo. Judge, my understanding is that the card change has been in effect for several years. Miss Collins, several years ago resided in Kentucky, and that's where the card was through when she was a resident of Kentucky. However, for the last several years, she has been a resident in Tennessee. And so that's where she has to make her application for that type of relief.
Where is it? Where is the child in school? Here or?
Here, Judge.
Well,
Yes, sir. I believe it's here.
I would think that, you know, to kind of advance this thing, it would appear to me that the child resides here more than the child resides in Tennessee. And here is where the medical card should be, because if there are providers here, you know, you got networks and stuff with TennCare, and TennCare is, from my old days in the legislature, is not, the coverage in TennCare is not as expansive as the coverage in Tennessee. Is that correct?
That is correct, Judge. And then also, Ms. Collins was a resident when this case, before there was a final ruling in this case, she was a resident of Tennessee. This child has always had a medical card here in Kentucky. The order specifically says the parents are to maintain that, not to unilaterally go and change it. And that child, all the providers are here in Kentucky who do not accept TennCare.
Yeah, we're not, you know, you don't have a response for that, Mr. Hendricks?
Yes, sir. My understanding is she did not seek to change the card. It was changed when her information was updated to Tennessee. She can't come in.
Well, why was she given information to Tennessee? I mean, if you say that you're a Tennessee resident and the child is a Tennessee resident, then they're gonna update. But what,
Judge,
go ahead.
yes, sir, because she had to update her own information so that she could get her own health care there. My understanding is she does not have private insurance. So if she also wanted to have benefits for her to cover her, she had to update her information. And the order requires the medical card to go either through her or the father, and the father has been incarcerated. So if she's tied to the child and she has to update her information so she can have coverage, then that seems to be what the mechanism was.
Judge, that's not totally.
Speak louder.
That is totally inaccurate. She contacted my client the end of October asking to see a copy of his medical card. My client complied as a joint custodian by providing her a copy of that. She took the child to the doctor, my client did, for an illness, and she discovered then that his medical card had been canceled. And specifically, the order that was entered on February the 15th of 2019 says that my client is the primary residential custodian and that this child goes to school in Kentucky. So I don't know how we interpret that in the last 6 years to mean that she's the one that carries the medical card. How does she list this child suddenly?
Yeah.
Because you
what
have
do you
to
have to say
update.
about that, Mr. Hendricks?
Judge, your order specifically charges the mother and the father to maintain the child's medical card. The father is incarcerated, so cannot.
Well,
so
I
that
know the father is incarcerated, but what,
right.
but Ms. Rose is the primary custodian.
Yes, sir.
Maintain, Judge, not to obtain a medical card for the child, to maintain the child's existing medical card, which the child was still eligible because he's a resident of Kentucky with my client. We didn't suddenly just have an update in the last 6 years of his eligibility for Medicaid. This happened as soon as she got a copy of the card, Judge.
And that is not my understanding of what happened. My
I've got
understanding,
copies from Kentucky showing when it stopped.
Well,
I've not seen those, Judge.
well, they'll be provided to you. She'll provide them to you. I just think I don't know whether it was intentional or unintentional, but I think this is a terrible imposition on the custodial parent or the Miss Rose, who has equal and as a third party respondent in this case is a custodial. I just think that this child ought to have a Kentucky card and that TennCare ought to be informed that the child resides primarily in Tennessee. And I just think that's what the orders say. And talking about maintaining them. And if anything, Ms. Collins violated the order by interfering with the maintenance of health insurance here in Kentucky. And I will tell you that the Kentucky K-CHIP is a more robust coverage than TennCare. And now you got all the providers up here where the child is and goes to school all the time that won't take it. And I would say that those Tennessee providers down there would be glad to get a K-CHIP card from up here. I don't know what the reciprocity is. You know what reciprocity is?
Judge, I don't think they accept it because the providers
They
are not
won't take
within,
K-CHIP.
their providers are not within the network.
So you don't think the Tennessee providers will take K-CHIP?
No.
Well, they take out of network. K-CHIP is, in my experience, takes out.
And I guess it's dependent upon the provider.
Yeah,
if they're
okay,
gonna
what's
accept
the
it.
other issue?
Well, Judge, one thing just to clarify on that, my client's been in contact with Kentucky, and unless Ms. Collins is ordered to change that information, they will not change it back to
Well,
Kentucky.
she is ordered
All
to
right,
change
thank
the
you. I'll submit an
information.
order that says.
There's gonna be an order. Now, what's the other issue?
The other issue is my client has asked to be able to declare the child as a dependent on her taxes because she's been primarily providing for this child. She's been covering if there was any uncovered expenses like over-the-counter medications and things. And so we're just asking.
How frequently is the child with Ms. Collins? Well, you want to swear her in?
Yes, I would ask.
Raise your right hand. Do you want to swear the testimony that God gives the truth, whole truth, nothing but the truth?
I do.
Okay, state your name.
Sherry Rose.
Okay.
She has Waylon on every other weekend except the last weekend of the month, which is mine. However, since Nathan is not available, I have his time as ordered by you. So she gets him again on December the 25th.
I'm just talking about.
Just in general.
In general, she has him from Thursday to Sunday, 2 weekends a month. Thursday till Monday morning, 2 weekends a month.
Okay. Ms. Hendricks, you want to question her about that?
I have no questions, Judge.
Okay, well, I'm gonna rule it that Ms. Rose does get the tax benefit. Is she eligible for the the federal tax benefits on the thing as far as the child?
I would think that she would be because the child is listed as a resident of her home and that
Yeah.
she has in a majority of the.
And Judge, just for the record, and I'm not sure it matters. The Kentucky Supreme Court has said family courts don't have jurisdiction to award that. They can affirm an agreement, but that the parties are to follow the IRS. I don't think it will matter, but just for the record, because I think under the IRS, whoever has a child most has the right to claim the
And that is
child.
correct,
But
Judge. We just didn't want a contempt motion filed against us because we weren't following the court's order. So we wanted to come to the court
Well,
to
I
make
guess
sure
you
the
put in
record
the
was
order
clean.
that the court has made findings that the child primarily lives with her, and that order could be submitted as part of any claim or IRS record. I think you're correct that I can't, although the federal courts quite frequently direct us things, unless we go into.
And Judge, is there a timeline on when she needs to go to get the Medicaid reinstated?
Within 5 days.
Within 5 days.
business days. Okay, is there anything else?
Of course, we had requested attorney's
I'm
fees
not
based on
gonna
this
award
motion.
attorney's fees, because I'm not gonna award you attorney's fees because I don't have any proof up to this juncture that she didn't have any malintent or something, so I don't have that. I'm not gonna award attorney's fees.
Thank you, Judge. I think that's all that I'm going.
Thank y'all very much.
Thank you. Have a good day.
Okay, Page versus Page.
Your Honor, I've not had the pleasure of appearing before you before, so is there a preference on which side you'd like me to stand on? Okay.
Side of justice.
Well, this looks like the side of justice.
Usually people just swap back and forth here because the camera's voice activated.
Understood.
Now, this is a motion to compel. As far as a check is concerned, and I read the, and you want there to be an itemization of costs involved.
Correct, Judge. We would like to see receipts of some sort, something that indicates the funds were actually spent on the marital residence, improving or repairing the damage. I did receive that email this morning. I really haven't had a chance to do more than glance at it, but about 9:30 this morning, I got an affidavit, I think, from the other parties, from Mr. Page. And based on that affidavit, I feel we're gonna have to have an evidentiary hearing. It looks like he just indicated he had paid cash for everything. So I don't know that, I think that means no receipts would be forthcoming. Included in those were $1,500 to himself for labor, $1,500 to 4 other people who I don't even know who they are, they're relatives, they share the last name, some of them do. So I think that I haven't had a chance to
If you
research.
cut
or
out
look into it.
everybody out in Monroe County shares last names, there's not gonna be anybody left to do any work, What's your position? Now, this was a insurance settlement check. What responsibility do you think your client has to prove that it was spent on repairing a property that was insured, and should there be any split of anything that wasn't used for that?
Sure, Judge. So this, just a little quick backstory. So there was a property, I'll be quick, I promise.
It's okay, I've got plenty of time.
On the property, there were 2 smaller building, larger building, and a roof. All 3 were damaged in a storm. This insurance check is to cover the repairs of those. The repairs that we listed in the affidavit are those that Mr. Page elected to do himself because it was necessary. He did pay cash. There aren't receipts available. I think the total of all that he spent was for $8,681.13. So it's our position that since he paid that out, that those will be released to him. The rest of that check, which is about $20,000 and some change, we would be fine with that going into one of our escrow accounts for us to then be able to go trace back. As for the property, the house itself, I think, is marital because I believe the parties built that together, Your Honor. However, Mr. Page does have a non-marital claim to the property that it sits on. Of course, that's more complicated than we need to get in today, Judge. So I agree that some of it probably needs to be split. And that's why
How much money will your client take?
Judge, we haven't even had that discussion. As I
Well,
said,
it's always good to come with some authority to say.
like I said, until I saw receipts, I mean, I got that this morning. I had no idea that was even coming. I hadn't even done that math. But like I said, I know at least 4,500 of it was supposed to.
I have no reason to disbelieve any affidavit, but wait, let me finish. It's good. You're gonna like what I say, okay? I have no reason to challenge because you hadn't had an opportunity to cross-examine. But it would appear to me that if we get into a situation where someone's claiming insurance receipts predicated on work they did themselves, that it's a slippery slope that, they says he didn't, she says she doesn't know, so he could get the whole amount that way. So, I would think that you need to get receipts, okay? And then also, if the check is for a certain amount, you need to say how much was that for the outbuildings and how much of that was for the house, what damage. I was sure it doesn't, the only thing I got is a copy of the check.
Sure. And Judge, we've made a fervent effort to obtain receipts thus far. That's why the affidavit was filed this morning, because we would have liked to have.
He's gonna get some time. I'm gonna give him some time, okay? we're gonna be back here on January the 22nd. And let's say by January the 15th, you get a detailed receipt situation to Ms. Coleman concerning where the money was spent. Do we have larger issues as far as property that needs to be settled rather than just focus on this? And if that's the case, I would probably want to just throw this all in a pile here. And as we did offsets and things like that, on the other personal property that is involved, and you say that there's a complication on where the house is located on land that she doesn't have any marital interest in. I mean, I'd like, have you deposed everybody in this case, or you waiting to try it, or what are you gonna do?
We have not done depositions. I will say it was maybe 2 weeks ago that I got the second set of interrogatories answered from their side. So the discovery is actively being exchanged.
Okay, well, let's just include, instead of, have that portion of the discovery finished by the date I gave you previously, okay? And then you can decide whether you need to take depositions or whether you're gonna try the case. I'm not really in a habit of counting spoons and going down through all the sort of things that I'm not gonna do that, okay? Unless you absolutely make me do it, and then I'll be in a very foul mood if I have to do that, So this is the sort of thing, it doesn't seem to me to be that much money involved in the whole scheme of things here. And at some juncture, after you get this information, I would think it would be in everybody's benefit just to make a dollar offer and see if that was acceptable to people, rather than going down through that sort of thing, okay? Okay, is there anything else?
I also had a motion asking the court to bifurcate the action.
I don't see anything, I don't think these people need to be married to each other, so I will bifurcate it, give them both a decree.
Okay, so I can
Just
submit that then.
electronically.
I will do that, Judge.
We have no objection to that, Your Honor.
Okay. Okay. Yeah, okay, that'll be
You
fine.
want us back here on the 22nd then, Judge?
Well, I tell you, when you get that information, you just determine, I would think it probably, since you had no deeper in discovery, that you probably don't need to be here unless you tell me that you've got an agreement, which I'll be glad to hear.
Okay.
But that gives you enough days when you receive this to file another motion to have it done with more particularity.
Sure.
Does that make sense?
Yes.
So just to
Okay.
clarify, Judge, you want all of that done by the 15th.
That's right. And I will tell you that I appreciate people that have a skill set to do things, but I doubt very seriously whether somebody's gonna be able to collect for labor they did themselves on property like that. I don't think the appellate court would look at that, because it's the sort of thing that you can't determine with any certainty. No. Okay, thank you very much.
Thank you, Judge.
Merry Christmas to everybody.
Merry Christmas, Judge. Nice to meet you.
Good seeing you. Okay. Okay, then we got all these motions to consolidate here. Who appears for the Cumberland County Hospital Association?
Judge, I am local counsel, excuse me, I'm local counsel for Cumberland County Hospital. Lead counsel, Mr. Brooker, is joining us by Zoom, Your Honor.
You ain't got no name?
Coleman Hurt, entering appearance for Cumberland County Hospital, Judge.
You ain't got no name. So you're Mr. Hurt, correct?
Local counsel only. Lead counsel, Mr. Brooker, is on Zoom.
Mr. Brooker, do y'all have any objection to the consolidation of this action?
We don't, Your Honor.
Well, that's easy enough. Is there anything else we need to take up here?
Your Honor, the other part of the motion that was requested was the appointment of interim class counsel.
Saw that, yeah.
Your Honor, we have no objection to that either. We disagreed with some of the characterizations in the brief and whether class certification is proper, but we have no objection to the tendered order that accomplishes both the consolidation and the appointment.
Okay. Okay, if you'll send me an agreed order, is there anything else?
Nothing further for the plaintiff, Your Honor.
It sounds like the sort of case that I ought to stub my toe and go to the Cumberland County Hospital and recuse myself from, quite frankly, but I'll try to refrain from doing that. Okay.
Appreciate it.
Now, let me ask you, while we got all these learned folks here for a poor country lawyer who doesn't do class action things or anything. When you get these sort of things like this, where do you go with damages?
Well, Your Honor, this is a complicated question and a very good one. There's mixed authority regarding the types of damages that are allowable. Plaintiffs will allege that the exposure of their personal information and their health information puts them at risk of having their identities stolen, having their credit affected, and especially with medical information. But again, this is plaintiff's position. That information is very valuable to the cyber criminals out there because people will use someone else's medical information or medical insurance to try to get care. And then if they don't pay the bill, which why would they? Because it's not in their name, then it comes back on the person whose information was lost.
Well, I kind of like to see the portion of these stolen information, the medical information, which I know is sensitive, people have the privacy and that sort of thing. I'd like to see what percentage of those patients were Medicaid patients and whether or not anybody would take any action against them or what value. I would, without fear of contradiction very much, I think a large percentage of the patients that go to Cumberland County Hospital or the clinic that's associated with it are probably Medicaid patients. And we all know how protective we are of the government's money under the Affordable Health Care Act and Medicaid. We're all out there trying to protect taxpayers. So in any event, but thank you, Ms. Van Note, for telling me that. I understand what you're saying. It appears to me at some point, if we get, and there's not a settlement, are these sort of cases, is this breach for informational purposes? Because I probably won't see y'all together again for the end of the year. If for informational purposes, is this an unusual breach, or were there all sorts of breaches, or is it the kind of software or the way the hospital here was wired? Did it make it particularly vulnerable to this, or did a lot of things happen that day to similarly situated small hospitals who are using the same systems?
Well, I think data breaches in general are on the rise, and especially against medical providers, but for the reasons that we already talked about. The exact mechanism of what the vulnerability was would be something that we'd have to figure out in discovery. But I will say for all the folks on this call, we handle dozens and dozens of these cases across the country. And this is something that's just really on the rise.
Yeah, well, and will be more so as AI and things sort of happen and people can hide their identity. I remember one of the most difficult decisions I ever made was a murder case I was assigned to in Eastern Kentucky, and I was trying to see whether these texts originated from someone that had been murdered and to see if they were still alive. And I made a strange ruling on that, but in any event, well, thank y'all very much for enlightening me, and I look forward to working with you. When do you there will be a lot of discovery in this thing?
Yes, I would expect this to take longer than your average case. The technical issues, of course, and then the experts that are involved. Class cases, if you can get them worked up within a year, I'd say you're doing pretty good.
Well, okay. Well, if it comes down to a jury trial, you can get one here pretty quickly because I don't allow people to schedule up jury trials until discovery's finished and instructions are submitted and we're ready to go. Okay. Well, thank y'all. Everybody have a happy holiday, depending on what your tradition might be. Merry Christmas, Happy Hanukkah.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you,
Thank you,
Your
Honor.
Bye-bye.
Bye.
Is that it? No, Hutchins versus Hutchins. Hudson versus Hudson. Let's see.
Hello, Judge.
Hey, how are you doing
today? Good seeing you. This is a motion, an affidavit for default judgment. I've got Mr. Hutchins here. He's my client. This is in a divorce action. He and his wife.
You need to speak up a little bit.
Okay.
I'm sorry.
Yes, sir. He and his wife, let's see, were married. Let me go back to the petition. All right.
Ladine,
They got married in 1995 and, let's see, they got married in 1995, but then they were separated in February of 1995. So, and they got married in Texas and, he's lived here in, Bergsville for longer than 180 days. And, but how long's it been since you had any contact with her?
29 years.
Okay, he hasn't had any contact with her for 29 years.
is there any property to be divided?
No, sir, there's no property to be divided. We had a warning order attorney appointed and she determined that Ms. Hutchins could not be located. She did her best efforts to
So this
file
is
that
just
report.
a decree of dissolution with no property.
Yes, sir, that's correct. That's been submitted, and the main purpose is for them to get divorced.
That's, would be the only purpose.
That's right. That is right. That's right.
Well, I'll be glad to do that, Miss Hutchins, she might have won a lottery ticket from me now, you willing to waive that possibility?
Yes, sir, that's, if she did, good for her.
Yeah, okay, well, that's a good attitude. You lived this long without her, so.
Yeah.
Okay, submit the order electronically, I'll sign it.
Okay, yes, sir. Thank you, Judge.
Yeah.
Merry Christmas.
Merry Christmas.
Merry Christmas, Judge.
Yeah, and then we got gold, that's a confidential matter. Okay, we need to clear the courtroom of everyone that's not involved in the confidential matter.